Counsel, let me go ahead and start the questioning here.
Yes.
All the cases in Kentucky that acknowledge that the presumption is rebuttable involve a dissolution of marriage. Is that not correct?
They are all, the ones that we've seen so far reported, have involved the dissolution of marriage.
Yes, we do not have any case in Kentucky saying that the 406-011 presumption of a child born in a lawful marriage is conclusive or rebuttable to third parties to the marriage, correct?
That's correct, Your Honor.
Okay, and that's really what we're going to have to answer here today, isn't it?
Yes, sir.
Okay.
In fact, it's exactly, Justice Scott, what I was going to begin with. The crux of this case is the definition of a presumption. We have had many in Kentucky. They go back to the very beginnings of our state, presumption of innocence, and in this case there are two presumptions. One is the marital presumption. The second is the presumption that the father is determined by DNA, and that is found in KRS 406-111, and that is essential. What you have when you have these dueling presumptions is the court hears facts and determines, based on those facts, who the father is.
Doesn't the paternity statute, though, reference the alleged father? Isn't that the key words?
The key word is putative father, which Blacks defines as supposed father.
And putative father is what?
Putative father is the person who comes forward, in this case, my client, Mr. Rhoades, who filed a paternity action claiming to be the father of this child.
Counsel, under your view, is there any limit on the ability of an outsider to a marriage, to some of any person, any man, to go into court and allege that he is the biological father of a child born to a married woman and presumably to her husband? Is there any limit on that, or is any family subject to that type of, and I'll use the term, attack?
Well, I might take offense to the term attack.
Okay, sure.
But there are limits, Your Honor. The limits are found within the statutory framework of Kentucky. In order to file a custody petition, it needs to be verified. It is subject to the same sanctions from the trial court of making frivolous claims of any other lawsuit. Additionally, there would be causes of action that could be brought on behalf of families that were found under, again, your word, attack by going to court. But what you have here is a two-pronged analysis, and I think this is what the Court of Appeals wanted to have in this case. They wanted to determine paternity at the onset, and the case was remanded to family court to take up the issue of paternity before such time as the court entered any orders, including those related to mediation or alternative dispute resolution. With respect to the statutory framework of Kentucky, there are two statutes that become important. The first is the 403 statute, which allows a parent to bring an action.
How do you define parent?
I define parent as fathers and mothers, and that's consistent with the statutory framework in Kentucky. There is no definition in Chapter 403.
Have you looked at 205-710, subsection 14?
No, sir.
Let me read it to you. Parent means a biological or adoptive mother or father of a child born in wedlock, or a father of a child born out of wedlock if paternity has been established in a judicial proceeding. Does your client meet any of those standards?
Not as of yet, but he's seeking the latter, and this child was born out of wedlock. It was born to a married woman.
You seriously argue that this child was born out of wedlock when the marriage was still intact and is still intact today?
Yes,
under
Justice
406-011?
Yes, Justice Scott.
There's a broad sweeping policy among trial courts in this state, I think, of not illegitimizing or use coarser language, bastardizing children. If we adopt your position here, will we not be illegitimizing this child and setting a precedent for that?
Well, I think both language, both terms, are perhaps inappropriate in 2007. This child is neither, in my opinion, a bastard or illegitimate for illegitimate acts committed by his parents.
So you're saying there's no such thing under the law anymore?
I don't, certainly historically,
Are you suggesting?
there were bastards,
Please go ahead.
and there were legal ramifications for being an illegitimate child. Under the term bastard, or the Latin, son of no one, a woman who had a child out of wedlock, that is not to her husband, had a child that couldn't be supported or inherited by the father, the husband, and it couldn't be supported by the mother. This was, going back 500 years, a manner in which a male-dominated society could control women. But this country and this state has taken away all those legal ramifications. We expect biological parents, that is mothers and fathers, to equally financially support and care for their children.
So you argue in your briefs that the presumption is outmoded in so much that we now have a much more exact way of determining parenthood or determining paternity. And are you also arguing that the presumption is not really in place to protect, to help protect the child from being illegitimate, declared illegitimate?
Not in a legal context, Judge. There's just no basis. There's no penalty within a legal system for a child that is born to a husband and wife.
What about inheritance purposes?
Pardon me?
What about for inheritance purposes?
No, well, in this case, you would make a mother sort of an uber parent where they could select whether they wanted their husband to support this child or whether they wanted the biological father to support this child. And it puts it in a situation where there would be a monetary incentive to make that decision.
Who is going to make the education decisions, the geographical location of living decisions, the church locations in this three-person family you're arguing for?
I'm not sure that I'm arguing for a three-person family. I'm arguing for something that's very common in Kentucky. That is, parents who share joint custody, one of whom is married to another person. Many times, both have become married to other people. Additionally, I'd like to take up the issue
Counselor,
of the social.
let me ask you a question before we get off of this. If you're talking about common law and what it used to be in that, in illegitimate children and the reasons for presumptions that we don't have illegitimate children, if you have a paternity suit, don't we have a shifting of paternity rather than a child that's going to be bastardized? I mean, your suit seeks to just replace paternity, fatherhood. But I mean, the child is still going to, although not inheriting from the father by marriage, will be inheriting from the biological father. And even a common law, when you acknowledge the bastard, then they had full rights. So the child wasn't a bastard anymore.
Well, certainly this child will not be without a father. There are two individuals competing
Right.
for fatherhood in this case.
But I mean, it's more shifting parentage rather than bastardizing someone, which is one of the reasons for the presumptions.
Under current law as well, let me just tag on to his question. In matters of support, paternity does not have to be litigated. It can be recognized as a legal fact if it is admitted. Is this not true?
That's true.
Go ahead.